Good afternoon, everyone. My name is Micah Schwartz. I'm an attorney with McGuireWoods Law Firm located in Charlottesville, Virginia. And I have with me two other attorneys in DC. You'll hear from them shortly. With me is John Moran and also Farnaz Thompson, against both of them in DC. Hopefully you can see them as well. Thank you for joining us for this webinar. We're going to be talking today about COVID-19 vaccinations and testing requirements that apply to higher education institutions in particular. A quick point about the technology here. Hopefully you can see us and hear us. If you scroll down to the bottom of your screen, you'll see that there is an opportunity to provide us with questions. If you have questions as we go, please type them in here. We find that verbal, oral questions during the presentation tend not to work that well. So we're going to save all questions to the end. But if you have any, please provide them and we'll try to get to them at the end. And if not, then we can all just talk separately after the presentation. For those of you who aren't familiar with McGuireWoods education team, we wanted to provide a very quick introduction. So we have over 80 attorneys and consultants in 15 offices throughout the United States. We know that education law is largely a local and state practice, but we have attorneys in almost every state, and so we're near you, and we know your practice areas, and we know your state and local laws. We do this kind of work for public, private, and for-profit colleges and universities, and also for lots of other kinds of entities that are affiliated with colleges and universities, like academic medical centers, and also foundations and endowments. Here's a loose agenda of what we're going to talk about today. So there have been three primary vaccine mandate rules issued by the Biden administration in the last few months. We're going to talk primarily about two of them. The OSHA Emergency Temporary Standard, which applies to all employers with 100 or more employees. And then the executive order, which is Executive Order 14042, which applies to some federal contractors and subcontractors, though not all. There's also a third vaccine mandate type rule that was issued by the federal government in the last couple months. That's the CMS Emergency Temporary Standard. It applies to some entities that receive Medicare or Medicaid funding from the federal government. We're not going to focus as much on that one today. Our impression is if you receive that kind of funding, you're probably aware of it and you're familiar with this rule. But if you have particular questions about this, again, please get in touch with us and we can walk you through it. We're going to focus instead primarily on the OSHA ETS and Executive Order 14042. It's worth noting that with all three of these, there have been stays that are currently in effect. So all three of these prongs of federal mandates that were part of the White House's path out of the pandemic are currently under a stay. There has been litigation that applies to all of them. They're all currently under a stay. We'll give some more detail on what that means as we go. And then finally, we wanted to note early that with all of these mandates, there are religious and medical exceptions that it may be necessary for an institution to provide. And so we'll give more detail on that as we go as well. First, let's talk about the OSHA Emergency Temporary Standard, or the OSHA ETS. So at its most basic, it is a vaccine or test mandate that applies to all employers with 100 or more employees. It is actually a little bit more complicated than it was first explained to be by the White House when this concept was introduced a couple months ago. Employers are required to require employees to either be vaccinated or test weekly for the coronavirus. But for those employees who choose to do the testing requirement, they also have to wear a mask in the workplace. And we think that's an important part of the policy that wasn't focused on much by the White House initially. So what we have is really not a vaccine or test rule. We have a vaccine or test and mask rule, which is likely to make that second option much less appealing to a lot of employees. Many of employees have probably found already don't want to get vaccinated, don't really mind getting tested on a weekly basis, but also don't really want to wear a mask. And those employers are going to be required to wear a mask in almost all circumstances in the workplace. But again, at its most basic, it is a vaccine or test and mask mandate for all employers that have 100 or more employees. There are some intricacies when it comes to coverage. We're not going to spend too much time here because we think that for most higher education institutions, coverage is going to be pretty clear. Most of you have 100 or more employees, and so there's probably not a lot of ambiguity here. But we did want to give some detail here. So the rule applies to all higher education institutions with 100 or more employees. If you are close to the 100 employee count, then you do need to know some of these details more. Part-time employees are included. So even if an employee is only working 5 hours a week, they're still going to count as an employee for the purposes of determining whether or not you have 100 employees or not. On the other hand, independent contractors are excluded. So we're only talking about actual employees here, not just contractors. But if you're a part-time employee, you do count. Now, even if an employer is required to require vaccines or testing from employees because they have 100 or more employees, that doesn't mean necessarily that every employee is going to be subject to this rule. Some of them are not. So fully remote employees, for instance, are not required to vaccinate or test. They're just exempted. They don't have to do either of those two things for, I think, pretty commonsensical reasons. They're not actually coming into a workplace where they're going to interact with other employees, so it's not necessary for them to be vaccinated or to test weekly. The same is true for employees who work exclusively outdoors. Again, I think that one's kind of commonsensical, though maybe not quite as clear. But the logic here is that the virus spreads less effectively outside. So if you work exclusively outdoors, OSHA is exempting you. You don't have to be vaccinated or test weekly. And then there's employees who do not report to a workplace where others are present. And I think both parts of that description are important here. So employees who do not report to a workplace are, again, kind of like the remote employees. If you don't report to a workplace, you work from home, for instance, or you even work in, say, like a WeWork setting somewhere, you don't have to be vaccinated or test weekly. At the same time, even if you do report to a workplace, if there aren't other people who are present there, you don't have to be vaccinated. The rule doesn't apply to you. So this may not come up very often, but it's worth pausing on for a moment. Imagine that you have, say, a researcher who's doing work, I don't know, maybe an archaeologist or something like that in Santa Fe, and they're in a one-person workplace, and they do go into a workplace, and it is a university office where they're the only person there. That person doesn't have to follow the rule either because they're not interacting with other people. And then finally, employees don't have to follow this rule if they are subject to one of the other vaccination mandates that I listed at the outset. And so that means the other two that we've listed so far, the executive order that applies to federal contractors and subcontractors, the CMS rule that applies to facilities that receive Medicaid and Medicare funding, and then also if you are a healthcare institution that is subject to the other emergency temporary standard that OSHA issued in the summer, then you don't have to follow this rule as well either. That applies to workplaces in particular that are covered by those rules. So this is important, I think, for colleges and universities. The fact that just some of your offices may be subject to those rules does not mean that the entire college or university doesn't have to worry about this OSHA rule. The OSHA rule is kind of like the catch-all of all of these rules that the White House has issued in the last couple months. If you're not covered by one of these other rules, then you're probably going to be covered by the OSHA rule. But on the flip side, you are not covered by the OSHA rule if you are in a workplace that is covered by one of these other rules. And again, that's the healthcare ETS issued by OSHA over the summer, the executive order that applies to federal contractors and subcontractors, and then also the CMS rule. Also, with regard to coverage, OSHA has provided us with some guidance with regard to complex business structures. That's actually the term that they use. And I think what is most relevant here for a university or a college is that affiliated entities may be included as part of one entity for the purposes of determining whether each of those entities are going to be covered. So let me give a specific example. If you have a large research institution, there's probably no question that you have 100 or more employees, so you're going to be covered by the rule. At the same time, you may have a foundation that's affiliated with the university, but doesn't have 100 or more employees. And so there creates the question, therefore, is that foundation going to be covered by the rule, given that they only have, let's say, 15 employees? And what OSHA has said is maybe. It depends on the relationship between the university and the foundation. If safety decisions are made by common managers between both entities, then they should be counted as one employer, and therefore both the university and the foundation are going to be subject to the rule. If, on the other hand, the foundation has its own, let's say, HR office and its own safety managers, and therefore is making its own kind of safety policies, and it has less than 100 employees, it's not going to be subject to this. It doesn't have to kind of attach to the university for the purposes of determining the coverage of the foundation. So this is, for those who are familiar with kind of the joint employer concept in employment law, this is just another version of that, I would say. You look to how the entity is managed, and if it's managed by the same managers as the larger entity, then the smaller entity is going to be covered by the rule as well. Similarly, with regard to temp employees or staffing agency employees, they aren't part of the count. They are included as part of the count with the host, or I'm sorry, with the temp agency. So if the temp agency has more than 100 employees, they're going to be subject to the rule. But the host employer, like the university or the college, doesn't have to include temp employees. They're excluded in the same way that independent contractors are. In addition to requiring vaccines or testing for employees, the OSHA rule also includes some PTO obligations for employers. There is as we talked about, the option for employees to choose to be tested instead of being vaccinated if the employer goes with that option, if it wants to allow them that choice. But you can tell that what OSHA wants is for employees to be vaccinated. And so there's a lot of aspects of the rule that are designed to help employees get vaccinated and to encourage employers to encourage employees to be vaccinated. And these PTO rules, I would say, are of that kind. So under the OSHA rule, an employer has to provide employees with at least 4 hours of PTO to obtain the vaccination. So in other words, employees have to be given at least 4 hours of work time to get the vaccination and be paid for that time, unless the employee chooses to be vaccinated during non-working hours. So if the employee chooses to get vaccinated on a Saturday, the employer is not required to then give that employee 4 hours of PTO. It's only if the employee chooses to be vaccinated during the workday. So you might say that this is incentivizing employees to get vaccinated during the workday. If they're aware of this, they would probably choose to be vaccinated during the workday, because then they get 4 hours off basically to do it. But if they choose to do it during the weekend, that's their choice, and the employer doesn't have to compensate for it. The OSHA rule also requires employers to provide time off for employees to deal with the side effects of the vaccine. So this is different than time off to actually get the vaccine, to get the shot in the arm. This is time off to deal with the sickness that comes with, for some people, getting the vaccine. The rule says that employers have to provide a reasonable amount of PTO in these circumstances. It's not as clear as the amount of time that's required for getting the vaccine. That's 4 hours for each shot, I should say. So that's 8 hours in the case of a double dose. The rule isn't as clear about how much time employees are required to get if they have side effects. Instead, the rule just says employees will must get a reasonable amount of time. However, we do have some additional guidance from OSHA here. OSHA has said, presumptively, if an employer has provided 2 days of time off for an employee to deal with the side effects of receiving the vaccine, that's probably going to be enough. In other words, they haven't used the term rebuttable presumption, but I think that's a fair way to interpret it. If the employee has received 2 days off, that's probably sufficient. The employer has probably done what it needs to do to comply, and it would be up to either an OSHA inspector or an employee to prove that it was really necessary to provide the employee with more than 2 days to reach this reasonable amount of time obligation. If employees are already granted paid sick time, then employers are not required to provide additional paid sick time for dealing with side effects. So in other words, employers can require employees to use their sick time to deal with side effects. On the other hand, employers are not allowed to force employees to use their vacation time to deal with side effects. And so what that means is if you're the kind of employer that has just one bucket of PTO, which is intended to be used both for vacation time and sick time, you would be required to give additional sick time to an employee to deal with side effects. On the other hand, if you're the kind of employer that has one bucket for PTO, or let's just say one bucket for vacation time and another bucket for sick time, and there's enough time in the bucket already for the employee to use that time if they're dealing with being sick from the vaccine, you as the employer can require them to use that sick time bucket to deal with the side effects. As part of this rule, it's now going to be necessary for universities and colleges to obtain a lot of records from employees. Some of you are probably doing this already. A lot of you may have vaccine mandates already. But if you don't, it's now going to be necessary to see vaccine records from employees. And so the rule, this is going to require a lot more, I guess I'd say, thinking about, well, what are we going to do with all these records? Where are they going to go? How do we ensure that we're keeping them confidential? Because we still have to comply with the ADA's requirements regarding confidentiality of medical records. So if this is the first time you're getting these kinds of records, again, you're going to have to do some thinking about how do you get them, where do you go, how do you keep them confidential. Thankfully, OSHA has provided us with some guidance about what kinds of records we can use to verify that employees have received the vaccine. This is the list here that they provided. I'll go through it quickly. They're the ones that you would expect, though, I think. So immunization cards from healthcare providers, that's going to count as sufficient certification that an employee has received the vaccine. Vaccine cards, that's what I think is probably most typical. It's the CDC cards. It's what I got when I got the vaccine. It's probably what most of you received if you got the vaccine. Those are going to count as sufficient certification of an employee getting the vaccine as well. Medical records that document the vaccine, those are going to count. Public health or government immunization records, those count as well. And then there's even this kind of catch-all term, which is going to catch almost everything else that is an official record, other official documentation containing complete vaccination information. Those are the kinds of records that will suffice to prove to an employer that an employee actually has received the vaccine and therefore doesn't need to test and mask on a weekly basis. If an employee claims that they got the vaccine and they had a vaccine card, but it was destroyed somehow, or they lost it, or the dog ate it, whatever kind of excuse you got, this doesn't have to be the employer's problem. OSHA has said that a signed and dated attestation from an employee attesting that the employee has received the vaccine is sufficient proof. And then finally, if an employer has allowed employees to use other kinds of documentation to verify that the employees had the vaccine before this ETS was issued, that kind of documentation, whatever it is, can still count as certification of employees having received the vaccine. It's not necessary for employers to go back to all of those employees and say, yeah, I know I said it was good enough that you gave me, X kind of record. Now I need to see your vaccine card. Employees kind of get grandfathered in under this rule. If they gave you some other kind of documentation that was sufficient for you as an employer before the rule was issued, then what you've got is still good enough as far as OSHA is concerned. Unless all you had was oral confirmation. And in that case, you do still need to get one of these kinds of more official records from the employee. All right, I'm getting to the end of my time here. I'm going to pass it on to Farnaz in a minute. The last thing I wanted to cover, and that she's going to cover it in greater length, is that the vaccine mandate that I've been describing, the OSHA one, and the other, including the federal contractor one that John's going to be talking about soon, there is what we've all now become very familiar with, which is the need to provide ADA and Rehabilitation Act disability accommodations to employees who say that they have a medical reason for not receiving the vaccine, and also accommodations for employees who claim that they have religious reasons for not receiving the vaccine. And in that second case, they would be relying on Title VII's religion protections, religious discrimination protections. So you do need to think about doing the interactive process with employees if they say that they can't be vaccinated for one of these two reasons, medical reasons or religious reasons. But it's worth noting that because OSHA's rule includes a texting option, there is really already an accommodation built into the rule. So if an employee approaches you and says, well, I can't be vaccinated because of X, Y, or Z medical or religious reason, the interactive process might be very quick. You can probably say, well, that's okay. You don't need to be vaccinated as long as you're willing to test on a weekly on a weekly basis and wear the mask when you're at work every day. So there is kind of built into the rule already this accommodation. It's worth noting, though, that employees can request an accommodation even to that rule, meaning it's possible that an employee could say, well, right, actually, let me be more clear. I can't receive the vaccine for medical reasons, and I can't be tested on a weekly basis for the same medical reasons. And in that case, an employer would still have to go through the interactive process to determine whether it's necessary to provide a medical or a religious accommodation to the employee who says they can't be tested either. So that's a very quick summary about how the religious and medical accommodation requests are going to work in this case. I'm going to pass it on to Farnaz now to talk about that in greater detail.
Thank you, Micah. As Micah mentioned, there's a potential weekly testing requirement that employers may use if the OSHA ETS becomes effective. But with that testing requirement, the test can't be both self-read and self-administered. So the employees couldn't use a self-test kit and use those results to fulfill that requirement. With respect to religious accommodations, I haven't seen too many people complain about the weekly testing requirement, although they may object to the specific type of test, in which case you could offer an alternative type of testing that is compatible with the person or the employee's religious beliefs. But really, when it comes down to religious accommodations under Title VII of the Civil Rights Act of 1964, there are two essential elements that an employee has to meet in order to receive a religious accommodation. The employee has to demonstrate that their belief is religious and that it is sincerely held. With respect to religious, the Department of Labor and the EEOC define religion quite broadly. It is really just your belief system, and it doesn't even actually have to be a belief in a God. So you don't have to have a belief in a deity. You don't have to be a member of one of the three major religions, Judaism, Christianity, or Islam. You can have kind of your own religious belief or a belief in something that would take the place of a deity, and that would be sufficient to demonstrate that you have a religious belief. However, the belief can't be social, philosophical, or just purely political. So the religious belief can't be, I don't think the government should have the authority to mandate us to take vaccines. It has to be rooted in some type of religious belief, whether it be a deity or some other type of system that would take the place of a religion. Now, the belief also has to be sincerely held, and employers may ask questions to determine whether the belief is sincerely held, although it's hard to ask questions about sincerity without questioning a particular employee's religious beliefs. And if you're questioning the belief to determine whether it's religious, that's permissible. But if you are questioning the religious belief itself, that is not permissible. So it's a hard line to walk to determine whether an employee's belief is sincerely held. And this is one of those rare instances where there's less liability for the employer to accept the employee's assertion that the belief is indeed sincerely held than to question it. Although, of course, employers may do so. It's just a hard line to walk. And if you want to demonstrate that the belief is insincere, it's difficult to do so because the religious beliefs don't have to be consistent. So an employee can literally believe or have a religious belief that it's permissible for them under their religion to take one vaccine but not another. So it's hard to demonstrate that the employee does not have a sincerely held religious belief, although it's possible to do so. So for example, if you have an email from an employee stating, I don't believe in this religion, but I'm just going to ask for a religious belief because I don't want to take the vaccine, then certainly you have great evidence that the belief is not sincerely held. With respect to the accommodations process, courts have endorsed an interactive process, but they have not required it with respect to religious accommodations. However, it's a great process, as Micah mentioned, to follow because then you have documentation that you offered some accommodations to the employee and the employee rejected them for whatever reasons. And it's really just the burden of an undue burden with respect to what the employer has to bear when there is a request for religious accommodations, and it's really just a de minimis burden. So if you can prove that it is more than a de minimis cost to the employer to offer the religious accommodation, you don't need to do so. But again, you should be documenting all the accommodations that you offer, what the employee offers in response, and whether that is indeed a de minimis cost or not to the particular employer. There is an EEOC template form with respect to religious accommodations, and that's actually a hyperlink, and the PowerPoint deck will be available to you. That is a very simple form to use. The EEOC has endorsed it, and unlike the religious accommodations form for federal contractors, which was subsequently revised by the government, this form has remained the same, and it's definitely one that employers may use, hopefully without any objection from the Department of Labor, because the EEOC put it out. With respect to medical accommodations, this is mostly under the Americans with Disabilities Act or the Rehabilitation Act. With respect to medical accommodations, you must go through the interactive process with your employee, but you also may require the employee to actually provide medical evidence in the form of a doctor's note or some other documentation from the healthcare provider that they indeed need a medical accommodation to perform their work. And unlike the religious accommodations test with respect to Title VII, the interactive process under the ADA is mandatory. So you have to go through a process where your employee requests an accommodation, and as an employer, you can consider that accommodation. Again, it's an undue burden here, but an undue burden here is much more substantial with respect to the employer than it is for religious accommodations. So an employer is required to provide an accommodation for a medical or disability request unless it would fundamentally alter the nature of the business or the operation. So there's a higher burden for the employer to demonstrate as to why an accommodation won't work in this context. And employers don't have to offer telework or maintain telework programs, but it has been an accommodation that's been successfully used. If that's not possible, then an employer really should document why telework is not possible, especially if telework was something that was offered earlier on in the pandemic. But there are absolutely factors that an employer can use to demonstrate that, and these factors come from the EEOC. So if the employer is not able to adequately supervise the employee, if the employee teleworks, that's a factor that you can use. If the employee needs certain equipment or tools, for example, at an outdoor workplace that wouldn't be available otherwise, then telework may not be an option. Or if the employee needs access to documents in a particular workplace, like if your employee works in a SCIF, then obviously telework may not be possible. But these are different factors that you should use, think about, document in determining what accommodations to provide. With respect to compliance deadlines, of course, the OSHA ETS has been stayed, but the original compliance deadlines were essentially everything that Micah mentioned had to be fulfilled by December 6th, except for the testing requirement for unvaccinated individuals. And then by January 4th, we'll see what happens in January, because there currently is a petition to lift the stay before the Sixth Circuit. But by January 4th, employees had to be fully vaccinated, although the OSHA ETS issued FAQs on the emergency temporary standard to clarify that as long as an individual had received both doses of a vaccine, if it's a 2-shot requirement by January 4th, then it was fine if 2 weeks hadn't passed before the last vaccine was taken. So really, it's a January 18th, 2022 requirement for being fully vaccinated. Most of the attendees today are in right to work states, but if you are not in a right to work state, you should be aware that the National Labor Relations Board's Deputy General Counsel issued a memo basically stating that covered employees under the OSHA ETS have decisional bargaining obligations because there's some discretion and with respect to what policy the employer adopts. And so those are things that you would have to work out with employees if there is a collective bargaining agreement. This is a slide we basically included just to give you an overview of the different requirements that you have to fulfill by December 6th, which obviously that's come and gone, but you would have had to have a policy on the vaccination, determine the vaccination status of your employees. So you might want to be thinking about how you would be able to accomplish these objectives if the stay is lifted. And with respect to penalties, with respect to a violation for just an initial violation, it would be considered a serious violation. It's about $13,653. And if it's kind of a recurring willful violation that you've had one or more violations with respect to an emergency temporary standard or any of the other OSHA rules, then the OSHA would consider it a willful violation, in which case the penalty would be approximately $136,000. And there's also criminal penalties for knowingly supplying false information or documentation. So Micah mentioned there might be some exceptions where an employee who doesn't have documentation that they were previously vaccinated can attest to that. But if they are lying, then they would be subject to criminal penalties. So the emergency temporary standard was supposed to be effective for 6 months. And so it's technically, if the stay is lifted, it would be effective until May 5th, but we'll see how the courts fare and how long the litigation takes. But you also should be aware that OSHA extended its deadline to receive comments. So comments are now due by January 19th, 2022 to determine whether OSHA should make this a permanent standard. And so OSHA can go through notice and comment rulemaking and issue a permanent standard. And OSHA could, by the way, change the rule, the standard, through that process to basically overcome some of the deficiencies that courts have found with emergency temporary standards. So stay tuned, because there could be a permanent standard eventually in the future. And John will talk about litigation, but currently the Fifth Circuit issued a stay, and then there are all these lawsuits filed, and there's a lottery, so all challenges to the OSHA ETS are now before the Sixth Circuit, and the Sixth Circuit has not yet lifted the stay, although the government has petitioned them to do so. Finally, I should note that some states have OSHA state plans that apply to both private employees as well as to state and local government employees. There are actually 22 states with state plans that apply to both local and state employees as well as private employees, and there are 6 with state plans that apply only to state and local government workers. But with respect to those states that have state plans, the emergency temporary standard stated that these states had 30 days to come up with their own rules that were just as effective as the OSHA emergency temporary standard. Obviously, the emergency temporary standard was enjoined before any of these state plans were developed or formed or put into effect. But if you are in a state with an OSHA state plan, you should stay tuned to see what your state does.
All right, and with that, I'm happy to head into this last piece here. Again, I'm John Moran, a partner in the DC office of McGuireWoods. I imagine that for many, perhaps the most interesting piece of this is an update on the litigation and where it stands. So I promise we'll get there soon. But first, wanted to give a brief overview of the contractor mandate. And to start, you might wonder, why is that germane to institutions of higher education? And I think there are a couple of reasons to be attentive to it. The first one is that it's stricter than the OSHA rule. So if it does apply, then it's more likely to create an implementation burden, and also has the potential to create conflicts and issues with employees. And the main reason it's different is because, unlike the OSHA standard, the federal vaccine mandate for contractors does not have a testing opt-out option. It is a 100% vaccine mandate and requires that all employees who are subject to it be vaccinated. At this point, the implementation deadline has already come and gone. So if and when it gets implemented, it would be effective essentially immediately. And in terms of institutions of higher education, there are kind of two main ways that this could become relevant. The most extreme, but I also think the most unlikely, would be for the administration to take a broader view that something like your program participation agreements with the Department of Education would themselves be covered contracts that would subject you to the vaccine mandate. More likely than that would be that on a case-by-case basis, many universities and colleges have various contracts or what the executive order calls contract-like instruments with the federal government that do not include mere grants for research, for example, but would include other research programs that go beyond the mere granting of funding, and could involve contracting with any number of federal governmental agencies. So the other reason to pay attention to it is because on the good side, these are supposed to be done through bilateral agreements. So you would get a notice from the federal government that we plan to add this either to a new contract that you're executing or as part of an amendment to an existing contract. So on the good side, you would have notice. On the downside, that notice might not necessarily go to the people who are thinking about this. And so one thing that we've advised a lot of our clients to do is, if you're concerned about the application of this, make sure that you're taking stock of who within your organization contracts with the federal government, and make sure they know what your institution's position is on these requirements, whether or not you're willing to accept them, and whether you have a procedure in place or a point of contact in place to be kind of a clearinghouse for these types of issues. Because what you don't want to have is a situation where somebody at a perhaps more lower level agrees in a contract with the government to accept the vaccine mandate, and now all of a sudden your institution is subject to requirements that perhaps the general counsel or deputy general counsel never knew about or never had the opportunity to weigh in on. So in order to kind of give you a sense for this, I'm going to run briefly through what happens if you are subject to the contractor mandate, so that you kind of have a sense for what it would mean to be subjected to it. It's not just a matter of vaccinating all your employees. So the first is you designate an implementation coordinator who's responsible for all of these requirements. And then the key piece is identifying covered contractor employees. The first thing you have to do is figure out who works on or in connection with the covered contract. And that in connection with language in the guidance is very broad. They give, for example, lawyers, HR professionals, accounting professionals, people who might not be doing the day-to-day work of carrying out the services that are considered by the contract, but who are there as essentially support people. So it is potentially very broad. And you then determine where those people work, and you designate those places a covered contractor workplace. And then the next step is you pull in all the other employees who work in those locations. So somebody might not be considered to work on or in connection with a government contract, but if they work in the same workplace as someone who does, then they would be covered by that vaccine mandate as well. And of particular relevance to institutions of higher education, the implementing guidance here, and just as an aside, that guidance is issued by an entity called the Safer Federal Workforce Task Force, which was stood up primarily to focus on the government's own workplace safety efforts, but is now also responsible for putting out guidance on the contractor mandate. Their guidance makes clear that if you have a campus, or anything where there's multiple workplaces that are adjacent, you have to pull in all of those workplaces unless you can affirmatively state that it is very unlikely that any of those people will interact, including in the parking lot or in lobbies or in common spaces that are shared. So the application, once it does apply, is potentially very broad. You then have to the implementation coordinator would have to make sure they distribute the required information. You would have to, here too, go through an accommodation process. This is a place where the accommodation of testing isn't built into the contractor mandate itself, but it would, in most cases, likely be a reasonable and available accommodation for a government contractor. And one notable wrinkle here on the joint employer situation, Micah alluded to a different aspect of it, but here, if you're considered a joint employer with the government, then you have to go through the accommodations process in coordination with the government. The vaccine mandate for contractors also requires the maintenance of records. The biggest difference here is that a written attestation from an employee is not sufficient, even though that would count under the OSHA standard. That's probably the biggest difference between the two. It also, this mandate also, it does have its own masking and distancing requirements. that you'd want to focus on, in your circumstances if you were subject to it. But they vary based on whether the physical location is considered a high or substantial community transmission area versus a low or no transmission area. And you have ongoing obligations to keep up to date both on any new guidance on the requirements, but also on the transmission levels in your area. And for transmission levels, if they go up, the change is automatic, and if they go down, there's a 2-week waiting period essentially to make sure that they stay low before you start implementing the lower requirements. The last key piece here is the flow down requirement. So contractors are not only required to implement this themselves, but they are required in turn to impose the requirement on any subcontractors that work under the same contract. So now I'll get to the point that may be kind of the most timely and the most interesting, and we've even had several changes within the last week, and that's a litigation update on where these various federal mandates stands. As Micah indicated at the beginning of the hour, there are currently nationwide stays in place on all 3 federal mandates. The most recent was on the contractor mandate that I was just discussing. The first nationwide injunction there issued yesterday from the Northern District of Georgia. The first one was the OSHA rule. Because of unique aspects of the OSHA Act and federal procedure. Unlike the district court challenges in the other cases, the OSHA challenges were all brought in directly in the federal courts of appeals. There were challenges filed in a majority of the circuits around the country. And there was there's a lottery procedure. Essentially, after 10 days, those petitions are consolidated, and literally, I think it was a ping pong ball in a machine like you see on the lottery drawings. The Judicial Panel on Multi-District Litigation selected the Sixth Circuit as the circuit that would hear all of these challenges on a consolidated basis. But before they could get there, the Fifth Circuit issued a stay of the mandate or of the OSHA rule that remains in effect today. Once the cases were transferred to the Sixth Circuit, the Department of Justice filed a motion to lift the Fifth Circuit stay. That the briefing on that will conclude very shortly. The Sixth Circuit received from the government a petition to expedite the briefing, noting in particular that their briefing schedule extended beyond Monday, which was supposed to be the implementation date of the standard, but the Sixth Circuit rejected that request and stuck with its original timeline. So, that will be briefed and argued in due order. It's hard to say for sure what the court's going to do, although at least that one indication suggests that the court wasn't rushing to decide this before it was supposed to go in effect. So they may take some time to consider the arguments and decide what to do. And all of this is happening against the backdrop for the OSHA rule of the May 6th expiration date, which, I think most agree does not get told just because, there's a stay in the interim. So, OSHA is likely moving quickly and keeping its eyes on a longer term standard as an alternative to, assuming it doesn't get this stay lifted in the short term, although it was something they would need to do even if they did get the stay lifted because it would expire in May no matter what. On the contractor mandate, there are currently 2 injunctions in place. The first came from a district judge in Kentucky. That one was limited to enforcement of the contractor mandate in Ohio, Kentucky, and Tennessee. And then, as I mentioned yesterday, in the Augusta division of the Northern District of Georgia, there was an injunction issued nationwide that restrains the government from implementing the contractor mandate. And then finally, on the CMS mandate, we haven't focused on that today, but there was a nationwide injunction issued last week in a challenge brought by several states in Louisiana. So again, at the moment, all 3 mandates have a stay in place, but getting a final judgment on these is going to take some time. They're going to work their ways through the courts of appeals and potentially reach the Supreme Court. And the interim relief may fluctuate. So, we have stays in all 3 cases right now, but if, for example, you had one of the courts of appeals reversed the decision to issue a PI, then one or more of these mandates could spring back into effect. And then, the parties could keep going upwards and they could be put back in place. So it's possible that we'll have some continued ping pong on how these go. And in any of those cases where that happens, there are going to be some, non-obvious issues, raised about how these things get implemented. So, for example, if you're, in cases where the mandate has already gone into effect, and you're on by its own terms, but there's a stay been in place, both the employer and the government will have to decide their position on questions like what's a reasonable amount of time, after the stay is lifted to be in compliance. Is there any, potential liability for not complying, before the stay was issued, or even theoretically during the stay was issued? I think that'd be a very aggressive position for the government to take. But those will have to be worked out, if and when we find ourselves in a situation where, the stays are lifted either temporarily or permanently. So with that, I think we're going to move. We've got a couple resources here. These will be in the slide deck on the OSHA mandate and on where you can find the guidance for the task force mandate if you're interested in looking at that. Again, given the stays, these aren't necessarily operational, although we've seen, for example, on the OSHA mandate, some perhaps at best conflicting messages from the Biden administration, including some statements encouraging people to go ahead and implement these, even though they've been stayed from enforcing them. And obviously, every institution needs to make a judgment for itself about how best to proceed. But you may want to look at these resources here. And I think with that, we're happy to start answering some questions.
Yeah, I think our first question is, how do you think state legislation prohibiting vaccine mandates play into these rules in the executive order? And generally, these federal they're federal rules, so there's generally a doctrine of preemption. So I think that courts will ultimately determine that if these rules were validly promulgated, they would preempt state laws. But there'd have to be a true conflict, really, between a federal law and a state law for a federal law to truly preempt the state law. So to the extent that there is a possibility of complying with both federal and state law, you should try to do that. And with respect to the federal contractor mandate that John described, there are instances where you could do that because the federal contractor work mandate applies just to the particular workplaces where the federal contractors are. So you have to be careful with respect to the doctrine of preemption because it really federal law only preempts to the extent that there's a true conflict between federal and state law.
Yeah, and I think to echo that, the trickiest situations are the ones where you have discretion as to how you implement, and you're inclined for other reasons to implement it on a more uniform basis of requiring vaccinations, whether you're talking about choosing the first option under the OSHA rule, or just deciding how you're going to implement the contractor mandate. And, it's not to say there would be no arguments that, if OSHA has told employers, we think you should have the option to require vaccination of all your employees, there might be an argument that even that would preempt a state law that said, you can't require all your employees to be vaccinated. But if the argument comes down to, pure conflict preemption, then you would say, well, if you have a way to comply with federal law and you have a way to comply with the state law, then you have to take it. On the contractor mandate side, this tends to come into play because, as I alluded to, a lot of the implementation choices about who works on or in connection with a particular contract and which workplaces are discrete and separate from other workplaces, a lot of those are difficult. It's not clear cut. And an employer could very rationally decide, hey, I'd rather just make this more administrable and do it for everybody rather than having to make difficult judgments about where it does and doesn't apply. And, that may be the best sort of business decision. It may create some risk that an employee says, hey, we're in a state that says you can't require mandates. Fine, if you're required to do it under a federal law, maybe, but you weren't required. You made a discretionary choice to expand it. We haven't seen those particular arguments, but that could theoretically come into play. But I think the overall principle, as Farnaz said, is that any of these federal rules where it applies would likely be held to preempt any conflicting state law.
And John and Farnaz, I maybe have a follow-up question for you on that. I'm wondering if you're thinking about this the same way I do, which is that there's also like a temporal, you might say, component to this, meaning that right now we have a federal law, right, which would preempt, except that it is stayed. And so therefore the state law is in effect. So it would, let's take Florida as an example, would currently be unlawful to require employees to receive the vaccine in that state, right? But then once the stay is lifted, then overnight it becomes unlawful to do anything but require them to, right? There is currently not a conflict, but there will be as soon as the stay is lifted, if it is lifted. Would the two of you agree with that?
Yeah, that's a great point. Or at least, yeah, potentially. I mean, it does raise tricky issues, and to put even perhaps trickier issue. I mean, you certainly have federal contractors who have already implemented the vaccine mandate as a term of their contracts and rolled it out to their employees, and then it raises the question of now that the rule has been stayed and the government has been stayed from enforcing it, does that stay an individual employer from saying, well, we've already rolled it out, so we're just going to keep doing it? Without getting into actionable legal advice, I tend to think that you could continue to implement something that you'd already rolled out. And what we actually saw as relevant to institutions of higher education in particular, what we saw over the summer is that courts are very deferential to employers who decide to impose mandates on their own, assuming it's otherwise consistent with state law and with your contractual obligations with your employees. Courts have looked very dimly on constitutional or statutory challenges that claim that an employer, or in particular an institution of higher education, whether it's acting as employer or acting as an educator of students, they've been very reticent to enjoin those efforts. And so, that sort of likewise raises the question of, even if it's enjoined as a matter of the government can't enforce it, is it something that the employer could do on their own anyway and decide to continue on their own? Although, again, that would be complicated by having a state law that purports to prohibit, certain forms of it. So, if you're in that situation where, you started rolling it out or you're inclined to roll it out, but, you're trying to figure out the stay, I mean, that's certainly something to think carefully about and consider kind of both sides of the legal risk. So, Mike, this other question up here may be a good one for you. And folks, again, if anyone else has questions, feel free to go into the Q&A feature and add those. So this question is, for the employee threshold for the OSHA rule, are the IRS controlled group rules applicable, or is there some other controlled group concept that would apply?
Yeah, that's a good question. I mean, I guess I must say I don't know the answer to it. The rule itself doesn't address it, and I don't believe the preamble does either. So for whoever posed the question, I saw that one as well. It's something that's worth talking about after. But I don't think IRS control group rules are going to apply here. But the rule itself doesn't state that expressly. So I think it's a point for further discussion. And whoever had the question, if they want to talk about it after, we could certainly do so.
And there's a number of other questions, I think, about students as employees. So certainly if students are full-time employees, they would count toward the 100 employee threshold, although that's not typically an issue for institutions of higher education. But with respect to students, it is harder, right? Because certainly they would be subject to the OSHA ETS requirements during the course of their employment. So would they have to wear a mask if they choose not to be vaccinated and the employer gave them the option of weekly testing? Then certainly they'd have to wear a mask. But if they're not acting in the course of their employment, if they're just being a student, and I don't think that the emergency temporary standard requirements would apply to them outside the course of their employment. But that is something that institutions grappled with in determining the scope of the OSHA ETS.
All right. Well, We don't have any more questions on the Q&A feature. Again, you still have a minute here to put one in if you're inclined. But as we said, these issues are in some ways simplified by the fact that there are stays in place for all three mandates. But in other ways, that's only a further complicating factor, because I think we're still far from a point in time where everybody feels confident that these things will remain stayed indefinitely. And so, if anything, it's perhaps a temporary breather for any institutions that felt like they were, scrambling to kind of keep up with these requirements. Although for those who are on the ball, it may actually just be a further complicating factor, and we certainly understand that. Looks like we do have one question. If a student is working part-time and is unvaccinated, what testing is required? I think we talked a little bit to that point, but I think it would be the same, to the extent they're an employee who's even, part-time working in the workplace, that they would be subject to the same weekly testing requirement. I suppose if their work were so sporadic that they weren't working even weekly, I don't know, Micah, you might know better than I whether there's some guidance to address that situation, but I'm not aware of it.
Yeah, I think it's a good question. And there's another one here about federal work study students working 20 hours a week. Yeah, these are good questions. I mean, I think the simple answer is, given that the rule does state expressly if they're a part-time employee, then they're going to count as an employee. Certainly the conservative answer is to say, if they are employees of yours, even for small periods of time during the course of a week, you should count them. Temp employees from staffing agencies, no. Independent contractors, no. But even, work study students, yes. But again, it's not expressly stated so in the rule. So there's at least some room for argument there.
Yeah. There's also a question whether we have any guess on the timing of the Sixth Circuit decision. As long as it's couched as a total guess, I'm happy to offer a mild level of speculation, acknowledging that that's exactly what it is, which is just speculation. We don't know which panel of the Sixth Circuit has been assigned to this matter. I expect that it has been assigned, but all the orders so far have been issued in orders just signed by the clerk of the court, which is not unusual under the circumstances. If it's a panel that were ultimately inclined to lift the stay that was issued by the Fifth Circuit, then you might expect them to move rather expeditiously to do that. You could infer from their denial of DOJ's motion to further expedite the briefing that they're not such a panel, but you might, that might not be the right thing to read into it. If it's a panel that ultimately intends to leave the stay in place, I don't necessarily see what the rush is to get it out, other than, just the general view that this thing's going to expire in May anyway. So you'd rather, give the parties a sense of the lay of the land. So, I think the earliest we would see it is late December, but my best guess is it'll be after the new year. Probably not too far after, just because, again, then you sort of start to get into, pocket veto territory where you just, effectively deny the motion by not ruling on it. But again, this is all sort of speculation, which I'm happy to do as long as it has that caveat on it.
And we've got, I think, one more minute, and there's one that I think I can answer quickly, so I'll take a shot at it. So the question is, what tests qualify? PCR tests, rapid tests? So the answer is yes, certainly PCR tests. So to be clear, those are the ones that aren't as fast, and they have to be read by a lab, so those count. With regard to rapid tests, which can be administered at home and aren't necessarily, they don't have to be read by a lab, those can count as long as they are not, and this is the language of the rule, self-administered and also self-read. So in other words, either the higher ed institution or a doctor has to be involved in either the administration of or the reading of the rapid test results. In other words, it's not okay to just take an employee at their word on a rapid test. An employee can't just say, I tested at home, here's and I got a negative on my rapid test result. And no one else, neither the university, college, or a doctor was involved. That won't suffice. It's 2 o'clock now, so I think that's probably a good place to stop. If we didn't answer your questions, we apologize. On this last screen, you should see all of our email addresses. Please reach out to us. We're happy to talk through these issues with you. And we thank all of you for joining us today.